This bill, which is section 23 of the bill, is to correct that area. And then because of some needs of other corrections in that area of the code section, the bar had asked to include some other areas, and
Yes.
and I'm not familiar with those. I'm not going to try to explain them. I want to
Well, we've got a bar representative here that can do that, as well as our own Representative Oliver, who's been intimately involved with the rewrite of the whole guardianship law.
And Mr. Chairman, I'd like to put a disclaimer in right now that I'm not here representing myself as an attorney or a lawyer under any means, and I respect that profession, but I'm a farmer, and I really don't know the law very well, except that I try to abide by it.
What's your crops?
And I go with all the peas. That's pecans and peanuts, and then I grow a little cotton and corn to go along with it.
All right.
But Representative Crawford, I've asked him if he would, if that's fine with you, Mr. Chairman, to carry this, and either he or Representative Oliver can explain the other part of this bill.
Thank you so much.
Thank you.
Glad to have you with us.
Thank you, sir.
Ms. Oliver,
I would like to be excused.
you are excused. We'll proceed and get a motion on your bill in just a second.
Thank you, sir.
Senator, thank you for your generosity in helping us out with this. This committee heard this bill in a different format, and as you can see, several of the sections, section 1, for instance, just inserts the word conservator. Section 2 inserts the word conservator. Section 3 addresses the person non-resident petitions to be a temporary guardian of a minor, and adds the option of having the petition filed in the county where the minor is found. Sections 4 through 8 were similarly technical sections. This bill was gone over pretty carefully and was a product of the fiduciary law section,
Correct.
and went over by this committee previously.
Yep. Invariably, when we have such an extensive rewrite of a law, we're going to have some cleanup come in
Yes, sir.
a year or so later, just because there's so much of it that has to be cross-referenced, and some of it doesn't come up when you even use a computer doing that until you start doing the reading and realize, oops, there should have been some language corrected in a particular part of the law.
Other than the technical changes, there were a couple of changes in section 21 and 22 that were non-controversial, but a little bit more, as this committee probably remembers, a little bit more substantive. When the General Assembly passed a public guardian provision last year under a representative forget his name, sorry, in trying to implement the public guardian provision, this sentence on page 8, lines 14 and 15 were just unacceptable to any bonding company. Actions
Right.
on a bond may be brought by any person aggrieved by the misconduct of the public guardian, so that language needed to be
It was
stricken. Unending. And I believe section 2 related to the discretion that probate judges have about being the depository of funds, and this committee judged, section 22, yes,
Yes.
sir. Yes, sir, section 22, about the authority of the probate judge to pay over any funds. And I thought we had limited that to, we had this discussion, and I don't see that we decided to limit that to $15,000.
I think that's earlier.
Okay.
That is under section 17.
Yes, sir.
We changed from 25 to 15,000.
Yes, thank you. That's just to refresh the committee.
And I'm sorry, section 16 and 17. That's right. 16 covered the judge's probate up to 15,000.
Just to refresh the committee's memory about our discussion earlier about
Yep.
this.
Anyone here wish to speak in support of or in opposition to Senate Bill 534?
Proper time, I'd make a motion.
All right. We'll entertain your motion.
Mr. Chairman, I move a do pass on House Bill 534. Senate Bill 534, and recommend back to the Rules
All in favor of the motion signify by saying aye.
Aye.
Opposed, like sign. The ayes have it. We have a due pass. I think at this point we'll go back to, for this one gets sent to bullets. Cleared out as soon as we could. We're going to do four bills in a row, which is Senate Bill 465, and we don't have Senator Edelman, but we do have Legislative Counsel here. Come on up forward. We'll let you do the presentation of these in his absence, since I'm sure you're as knowledgeable on this as he would be. And Mr. Wayne Allen from Legislative Counsel. Glad to have you with us again.
Thank you, Mr. Chairman. My pleasure.
We'll start with the Senate Bill 465, which is a general correction into the which areas?
This is the general revisor bill, which extends throughout the code with the exception of titles 21 and 47.
Okay, that's retirement and elections.
Elections, yes, sir.
All right, sir.
Mr. Chairman, I'll give just the briefest background for the benefit of the committee. Each year, the Office of Legislative Counsel, serving as staff for the Code Revision Commission, which has charge of publication of Official Code Georgia annotated, our office prepares 3 annual revisers bills to clean up and make minor corrections to the code. The General Revisor Bill, which you see before you, is Senate Bill 465. The Retirement Revisor Bill, which is Senate Bill 466, and the Elections Revisor Bill, which is Senate Bill 467. We break out those 2 titles for a couple of reasons. The Elections Revisor Bill is broken out because it requires Justice Department approval. The Retirement Revisor Bill is broken out because it has to have a certificate from the state auditor. Otherwise, the entire revisor bill would become a retirement bill.
Yes.
That is, in a nutshell, Mr. Chairman, what you have before you. We focus particularly in the General Revisor Bill. Each year, the Code Revision Commission has to give approval as to what volumes are to be replaced in the following year. That focuses our attention to try to clean up those volumes before they go into the new bound volume. So a lot of what you see in General Revisor Bill is focused on those particular volumes. We also pick up other areas that need prompt attention. That's the summary, Mr. Chairman.
Any questions of the committee of Mr. Allen? I've got one.
Yes, sir.
I'm looking at section 1 of 465, and we're changing, and I usually think, well, I can see there's been a misspelling, a punctuation error. We're striking Bill Elliott Day and putting in its place Bill Elliott Day. Spelled the same way, capitalized the same way.
There's one, if you'll notice real close, there's one internal set of quotes added on the replacement of Bill Elliott Day. See a double quote?
Oh, a double. My goodness. It's like these word puzzles. You look at the paper, try to, where's the difference in these 2 pictures?
Yes, sir.
Okay, so I see we got extra quotation there. My goodness. Okay. Any other questions? I'm ready to accept a motion. All right. Motion is due pass on Senate Bill 465. Any discussion on the motion? Ready to vote on the motion? All in favor of the motion signify by saying aye. Aye. Opposed, like sign. We have a due pass on 465. We'll move into 466. Tell us about this one, Mr. Allen.
This is the Retirement Code Revisor's Bill. As I mentioned earlier, it requires a certificate from the state auditor. Similar types of changes made only to Title 47.
All right. Any questions of Mr. Allen, presenter for 466? Ready to entertain a motion? We have a motion due pass. Any discussion on the motion? All in favor signify by saying aye. Opposed, like sign. We have a due pass. Next is Senate Bill 467. Mr. Allen?
This is the Elections Code Revisor Bill. As I said before, this is broken out because it requires approval by the U.S. Justice Department on the Voting Rights Act. Again, these are similar changes in the Title 21.
Any questions of Mr. Allen regarding Senate Bill 467? Any discussion among the committee? Yes, ma'am.
Because this deals with the election code, after its passage by the General Assembly, like any other bill dealing with voting rights, it requires Justice Department approval.
Anything further of Mr. Allen or discussion among the committee? I'm ready to entertain a motion. That motion do pass. Any discussion on the motion? Ready to vote on the motion? All in favor of the motion signify by saying aye. Opposed, like sign.
Thank you, Mr. Chairman.
Thank you, too. Pleasure to see you again.
Thank you. May I be excused?
You may be excused, sir.
Thank you, sir.
We have next is the Senate Bill 469, and this deals with the corporate code. We have several changes occurring in the corporate code. You're going to be presenting this, aren't you? That's right. Come on up, have a seat as presenter, Mr. Tumlin. Tell us first, whose bill sponsor was this of the Senate side?
Yes, it was Chairman Smith.
Chairman Preston Smith, all right.
I guess I brought a prop. All we're doing is just changing this entire section.
One book. One little book.
One little book.
It's a simple bill, right?
A simple bill about Title 14. And just,
right.
If you have any questions, most of the answers are in here. But
have fun finding.
What I'd like to bring to you, I guess, from time to time, and in intervals of 2 to 3 years, our business code section is ever changing. You know, it's influenced by other states. We're in competition with other states, the bankruptcy code, and just even tax matters. And this was a bill that originated as a project within the business law section of the Georgia Bar. And as we all know, the law section one that deals with business litigators to small business practitioners to large business practitioners. And also you'll see sprinkled throughout the bill input from the Secretary of State. You know, fees dealing with the Secretary of State was open to us. It was brought before the whole bar, and the state bar has recommended this. And just to go over this, and for the more technical aspect, I have Tom Ritchie and Lou Spelius that you can ask them to join me now or whatever y'all choose.
Would you like to come forward and sit with the presenter? You have a chair on each side, one on each side if you'd like.
And they've lived with this bill for probably over a year or maybe even 2 years in their practice. So if I could just give the overview, and as sections need more explaining, I'd like to solicit their support there. Basically the bill deals with bankruptcy, which is section 1 of it, which is that we confirm that order for bankruptcy court may be implemented by a corporation without shareholder approval. That's just, we're not locking the shareholder out. They're just things that board of directors have to maintain. And then deal with shareholder issues approval. There's directions that the board makes, whether or not they're compelled to make a recommendation, whether or not they can amend it after the recommendation's been made. And I'm going to go through it fast now, but
I think we might do a suggestion. Let's talk about them section by section if we could, and that way if there's a question on the committee regarding the language of a particular section, we can address as we go through. Anything as far as section 1? I'd like to ask, if I may, of either the presenter or your guest, what would be a type of order that's coming out from the bankruptcy court that the corporation would implement without having to go through the steps of getting either directors or shareholders' approval?
I can answer that. It would be, for example, a sale of assets out of bankruptcy. Sometimes the company declares bankruptcy in the most
Chapter 11
Chapter
type?
11, Chapter 11 reorganization, that's right.
Okay.
And in the reorganization, the court and its creditors may at the time determine that the best interest would be to sell to another company. And that ordinarily, under the code, requires board and shareholder. In this case, what we're saying is if the bankruptcy court orders it, then it can go through without having to go through that board and shareholder approval.
All right. Does that come as a sort of, I call it a uniform provision from the ABA? I know you said Delaware has implemented this. I just wonder if it's something that's
I don't know that it's in the Model Act. I know that it has come up in the context of questions that have come along the way when you get an order of bankruptcy court. Is the federal order, does it trump state law? And I think the general consensus is that it does, but when you look at the code, there's some ambiguity and some concern that it might not.
Thank you. Good explanation. Any other questions? All right, Mr. Tillman.
Section 2 deals with, allows the corporate board of directors to submit a matter to the shareholders, even if the board subsequent determines to recommend against the matter. And I think it's just, is that the one you'd like to address?
I can. It makes it possible for matters to be presented to the shareholders, even though the board itself may be conflicted and therefore not in a position to make a recommendation or may be opposed to it. So it's possible for shareholders to actually entertain and approve something that the board doesn't want or can't make a recommendation on. So it just makes it very clear that that process can go forward that way and that the shareholder democracy can actually take hold.
What would be an example of that to come about?
Well, there are instances, especially in a close corporation setting, where the board of directors are the same as the officers or maybe majority shareholders. In any case, they're going to benefit from the transaction personally.
Yeah.
And their recommendation, they may not be in a position to have an independent recommendation. There may not be independent members on the board, so that it's possible for that to be submitted to the shareholders. The problem with the existing law is there may be an ambiguity here that the shareholders don't even get to pass on something if the board doesn't recommend it, because the board recommendation is like a condition for there to be shareholder action, and this clarifies that and allows a green light to go forward.
Okay. Any other questions? Yes, sir.
This provision will allow the shareholders to take on their own initiative a proposal without it coming to the directors. Is that right?
Oh, well, that's actually, I think that's possible under other sections. But there are circumstances where the board is presented with a proposal, and they may favor it, but they may be conflicted. And so it allows that to go to the shareholders without a recommendation of the board.
Thank you. Any other questions? Proceed, Mr. Tumlin.
Section 3 deals with a Secretary of State procedural matter, in which a corporate name reserved under Code Section 14-2-402. That's just going how the Secretary of State conducts her business now.
Correct.
Section 4 deals with indemnification, and it deals with two things where a director is entitled to be indemnified. One, under this provision, he could ask for an advance. Instead of waiting to the very end of the trial, well, I'll let them explain, but you can ask for an advance instead of waiting to the very end. And secondly, that if it's in the Articles of Incorporation or even the bylaws, it is indeed an obligation of the corporation.
Yes, sir. Any questions? I guess I always assumed you have by indemnification they would be paying it as you go along anyway. Has it
Well,
been?
and the code does authorize that. It authorizes the corporation to obligate itself to do that. The problem comes up when there are articles and bylaws that say that the corporation shall advance the ongoing defense costs, because that's when you need them, when the litigation is going on. And the officer or director may be out of favor for some reason, and the corporation just ignores the request, and you have to take them to court. And this allows, this helps that process by making it possible for the court to handle that sort of thing on an expedited basis as a summary proceeding, so it doesn't have to go through full discovery and jury trial. And it also helps the officer or director by making it possible for him or her to collect legal fees anytime they have to go to court and enforce their indemnification rights, whether it's for advancement or whether it's at the end of the proceeding. They can get legal fees if they win.
Thank you. Any other questions of the presenter or guest? We'll proceed section 5.
Got a little in a hurry. I pulled in one of the things of 5, but basically section 5 says, as to being indemnified, this does not limit it. Whether or not somebody has it in their articles of the bylaws, the corporation still has the right to indemnify somebody, I guess, by board action or corporate action. And in no way does this limit a corporation's ability to indemnify somebody, a director or a corporate officer.
Any questions regarding section 5? All right.
Section 6 deals with a board of directors making recommendations to shareholders as to amendments, I guess, to the articles of incorporation. But it says they may do it, but even though it says shall, they can refrain from it if there's in some way a conflict of interest between the interests of the directors and the shareholders. In that case, they can withhold transmitting a recommendation.
Any questions? All right. We'll go to section 7.
Section 7 is deleted in its entirety, and that's just okay. And that's in reflection back to section 1 to the bankruptcy law.
All right. So we're striking where we would have some conflicting provisions here.
Yes, sir.
Okay. Go ahead. Section 8.
All right, section 8 deals. We're going to the exciting world of mergers here, and it's talking about how you can acquire stock, whether by cash or how they're converted. If you have a little bit more here, I don't do many mergers. So if you can help me with that, Lou, if you don't mind.
The genesis of this section is that in a merger transaction, in a merger, the shareholders can get cash, but they can also get stock, and they can get promissory notes and other forms of consideration. And what has kind of come to pass is that in merger transaction, you might have some shareholders who are unaccredited investors. They are subject to different protections under the securities laws, and that requires an additional layer of bureaucracy and procedure, etc. And what this allows a corporation to do is to give some shareholders one form of consideration, give others another form. So the ones that may be unaccredited can just get cash, and the ones that are accredited, wealthier, more sophisticated can get stock, and then be able to comply with the securities laws that way without adding too much difficulty or bureaucracy to the transaction.
All right. Any questions as to section 8? This
is just a continuation of it.
Okay, I've got one. Well, not his. I got a different one now. Gotcha. Thank you. Ready to proceed to section 9?
Yes, sir. Section 9 is a continuation of that on how they're bought and what the method is. All right,
there's one addition to that section 9 brings in, and that is that after the merger is approved by the shareholders, it is possible for section 9 to make non-material or ministerial changes to the merger agreement without having to go back and vote.
Okay. Kind of like what we do clearing up the law, huh?
That's right.
Okay. Any questions on section 9? Ready to go to section 10, Mr. Tumlin.
All right, section 10 is similar to the language we talked about in terms of amending a corporate charter. In this case, is a board shall make a recommendation to its shareholders about a merger, but if there's a conflict of interest, they have a right to refrain from such. So it's the same language except amendments to mergers.
All right. Any questions on section 10? Ready to proceed? Section 11.
And this is the next section over. This is similar to sections 8 and 9 over the different ways that between different classes can be acquired, the form of payment.
Any questions on section 11? All right, let's go on to section 12.
Section 12 is the procedural form of laying out a plan of a merger.
Yeah. This ties in what you were saying earlier about the balancing out value, but could be in cash, could be in stocks, could be in notes.
Right. And this doesn't, it's worth saying, this doesn't affect at all the fiduciary duty of the directors to treat all the shareholders fairly. It's just,
Right.
in terms of treating them fairly, as long as the value is the same, which is a question of form.
Any questions regarding Section 12? All right. Section 13.
All right, Section 13 has expanded the code where, listen to as we go, where corporations, where limited liability companies, limited partnerships can, in both ways can convert into corporations. Our code doesn't provide for all entities to be able to convert it to another, and this just expands it.
We're changing some of the outlining of these sections. Let's see.
Yes, sir.
Okay.
Yeah, because it affects limited partnerships, LLCs, corporations.
These are all technical changes. Okay. Any questions, Section 13? We're on to Section 14.
All right, Section 14, we're dealing with foreign entities that are registered to be in the state of Georgia. And, you know, just like we changed Georgia Corporation, Georgia's LLCs, the right to convert, this also gives a format for foreign corporations or foreign LLCs to convert to another type of entity.
Yeah, again, so they can do business in Georgia.
This where they have now become domesticated as a Georgia LLC, where they were previously, let's say, a Florida.
That's one possibility.
Okay.
It also allows a Florida, for example, Florida LLC that is registered in Georgia to convert to another entity in Florida. And then just affect the registration here. And it's just, what it does is streamlines the process and just let the Secretary of State collect the fee, make a change on the records.
This is really exciting stuff, too, isn't it? Okay. On to Section 15.
All right, Section 15, this is our third such similar language concerning a recommendation by a board of directors. And in this instance, it's talking about for the disposition of majority of the assets. Same thing.
We had earlier, yeah.
Right. It's the same language that if there's a conflict of interest, then they do not have to give the recommendation.
Yes. Any questions? Move on to Section 16.
Will one of you help me with this one?
Same point. Section
16. It's dealing with larger corporations.
Yeah. So more than 2,000 shareholders. Pretty much listed type companies, I'm sure.
Yes, this relates to, yes, that's right, stock exchange listed companies and the requirement to give go through this procedure, and the stock exchange rules govern that.
And that would override the exchange rules?
No, what this is saying is that in a sense what this does is allows the exchange rules to come in and control.
Okay. Any questions on 16, Section 16? Okay. Get you. All right, cool. I'll hold it till you get back. Excuse me, go ahead, I'm sorry. Section 17?
Section 17 is the fourth in the line of the similar language of director recommendations. And in this matter, it's dealing with the dissolution of an entity.
Right. Any questions? We'll go on 18, Section 18.
18 is procedural in nature. It's the procedure for a foreign entity to amend their certificate of authority, and just the do's and don'ts for the Secretary of State.
Okay. Any questions regarding Section 18? Move on to Section 19.
19 is a Secretary of State item, and
Same thing we did before, that
Same thing we
taken
did
out
before.
or registered.
Yes.
Okay. Different area of the code. Section 20.
this is a conversion for limited liability. This is a conversion, the conversion section for foreign limited liability and foreign limited partnerships. So we're making similar changes
Again.
per
technical change.
per entity, and then plus the overlay of foreign in this
All right.
case.
Any questions on section 20? We'll go on 21.
We get to this one?
Yeah, this is just going the other way. This is domestic over foreign.
All right.
That, the one concept affects, as you can tell from the
Right.
lot,
Okay, this
lot
is
of
the
different sections.
Okay.
Any questions about section 21? Move on to 22.
22 is procedural too over what a foreign limited partnership has to do to get certificate of authority from the Secretary of State. And it's taken out,
Notary.
yeah, it's taken out the notary section.
Okay. Section 23. This is again, what we talked about earlier, I guess the same thing, the technical parts of
It's
it.
procedural for the foreign limited type entities, limited partnerships, limited liability companies. And that's Secretary of State type request.
All right. Any questions, section 23? On to section 24.
Same. This is also, it's just continual procedural.
Okay, it's still, yeah, this is still procedure for the Secretary of State for the foreign corporations. And
As I look over 24, 25, and 26, all have that same thing, dealing with the limited liability corporation.
yes, sir.
And again, have those changes as reflected under the regular corporate, domestic corporate provisions,
Yes, they make the change I made right.
all the way
LLC,
through
LLC.
each level.
That's right.
Let's move over to section 26.
And this is the same
Same
thing,
thing,
and it's
yeah.
dealing with mergers
Okay.
for foreign limited partnerships, limited liability.
How about section 27? We got a
This-
fee change here.
It's for the Secretary of State for asking that go to $95.
What is it now? Is there any fee charged? I guess we didn't ask it. Usually we have a strikeout and a new amount
I
put
don't know
in.
if it's new or not. to be honest
We
with you.
don't have anything apparently. So we have a conversion by a foreign entity. Apparently it was not a fee set up to cover that as a registration with the Secretary of State. Mr. Middleton.
Mr. Chair, my recollection on that, we worked, the Secretary of State's office asked us to revise that point. The original draft that we had them taking care of that in their rules and regulations. They
Okay.
pointed out that they always did those costs statutorily.
Yeah.
Because of the change we're making, this is a new procedure that's being recognized, and the amount that is there corresponds with the domestic transaction that takes place, and it's the
okay.
same amount. And I don't know if that's reflected in the language of the bill or not, but that figure that is for this conversion
Yeah.
is the same. It was the figure that we got directly from the Secretary of State, and it corresponded with what they do
So
domestically.
what we do domestically, we charge 95. We're saying let's do the same thing when we have a foreign corporation
Yes, sir.
conversion.
That's my recollection of what they asked us to do.
All right. Any questions on section 27? Last 28.
28 deals with I guess for a withdrawing partner from member from a limited liability company. And it just gives them the
It's
two
always,
formats that they can dissent.
yeah. They can dissent.
Right.
Okay.
Yeah, they don't have the same shareholders in, but this one adds from 1 to 2.
That's usually addressed by their agreement, isn't it?
Quite often, yes.
Yeah. Okay. And is this making it statutorily something dealing with the rights of a limited liability company owner as to their way of getting removed? That's beyond what we do in the agreements.
Actually, what it does is it's just adding one more incident to the statutory procedure that's already there.
Okay.
And it's not a departing limited liability member, but just an existing limited liability member who has a right to object and dissent from an action being taken.
Okay.
And it adds this plan of conversion to that. It's not just a merger they can dissent from, or sale of assets. They can also dissent from one of these conversions.
Any questions of the committee on the bill? I'm going to hold up a motion this time. Reason being, Ms. Travis mentioned there's a grammatical error in the bill that she had to go back upstairs to get the information on it. So when she comes back, we'll then have Ms. Travis present what she's concerned about as a part of the bill, and then we can get the change made and proceed with it. Okay?
Mr. Chairman,
Yes, ma'am.
I just want to add something that
Oh, yes, ma'am.
it will be of interest to this committee. When I went door to door in my first election to Mr. Ritchie's house, he had one of those dogs that didn't make a sound when it were like I will never.
How long ago was that, Ms. Oliver, the first time?
But I knew that a dangerous dog was one that doesn't make a sound when it many times I wouldn't be of interest to everybody, but I knew that would be of interest to those of you that understand the kind of dogs that are.
Do you still have that dog?
No, had to destroy it.
You did? Okay.
For that very reason.
That's the very, very reason. Okay. I'd like to. A mud. It was a beautiful mud. I'm going to entertain a motion, if I might, for someone to table Senate Bill 469 until we have Ms. Travis back. The move to table. Any discussion on the motion? All in favor of tabling at this point signify by saying aye. Opposed, like sign. Then we'll table and hold this until she's back.
Now, you can refrain from voting, though, according to this new document.
That's right. Okay.
You still have bad feelings.
We're going to take up Senate Bill 573. This is Senator Carter's bill. I don't know if we've got Senator Carter coming. Is he planning to come?
Mr. Chairman, he's not going to be able to be here. Representative Crawford was going to handle that for us.
Who is? Oh, that's right, Crawford. He's out of the room somewhere.
Trying to get him right now.
Okay, let's hold up till he gets back in for a few minutes. Just be at ease. Crawford's right out here somewhere, I believe. Is he in there? I'll get him out if he's ready. See if he's ready. Never done what? Oh, yes, I did. I did my first election, about 1,500 out. $463 since you're back. I'm sorry, $469. All right, the motion is removed from the table. Any discussion? All in favor of the motion signify by saying aye. Aye. Those opposed, like signs. We have Senate Bill 469 back before us. Ms. Travis, you mentioned you had something you wanted to bring to our attention.
Just some grammatical issues that occurred several places. If you turn to page 19, line 6.
Line 6.
Line 6 and 7. The no later than 30 days after the conversion, which occurred on line 7, that actually modifies when the notification takes place. So that phrase should occur after the Secretary of State. So the sentence should read, the foreign corporation shall notify the Secretary of State no later than 30 days after the conversion
Right.
that such conversion has occurred, using such forms, and the rest of it.
Gotcha.
And that change, that language occurs on page 19, it's at lines 6 and 7, on page 19 at lines 21 and 22, on page 24 at lines 12 and 13, on page 24 at lines 27 and 28.
You're getting ahead of me. I've got page. I just finished 19. What was the second page?
Page 24, lines 12 and 13.
Right.
Page 27, I'm sorry, page 24, lines 27 and 28.
Page 27. Well, I'm sorry, the
Line
27, 28. Okay, yes, here it is.
Page 27, lines 33 and 34.
27. Okay, get that one. What line on 27 again?
33 and
find page 28. 13 and 14 on 28. Okay, here we are, yeah. I'll entertain those changes as a motion to amend, and move to amend the changes to correct the language to read, and I'll just read the phrase again. In this case, the foreign corporation shall notify the Secretary of State the changes down those areas no later than 30 days after the, whatever happens, conversion, that such conversion has occurred, using such form as the Secretary of State shall specify. And that's the manner of it. Any discussion on the motion? All right, we have a motion to amend. All in favor of the motion signify by saying aye. Aye. Opposed, like sign. We will have this as a what would be a committee substitute, House committee substitute to Senate Bill 469. I have a motion to do pass. It's been moved. Any discussion on the motion? All in favor? Yes, sir.
I got one question.
Yes, sir.
This being the second year, and this is the chairman's bill, if we got anything hung up in the Senate that we need on?
I don't know of anything at the moment. We've got, of course, 1313 in the committee. That's I'm sure going to move forward based upon the governor's desires.
I mean,
yeah.
And I asked that. It sounds joking, but I asked that seriously.
Yeah. Well, I think what we could do, if there's a problem like that, is through rules we can, I think, address it. I think we can handle it. Find out that way. Sure do.
That's just politics.
I understand. All politics played around here. More than we want to talk about, probably.
I've been a victim of it.
Have you? Anything going on now, or?
No, sir.
All right. Not at the moment. Proceed with the motion then. Any further discussion on the motion? Motion is due pass as amended. All in favor signify by saying aye. Aye. Opposed, like sign. We'll have it as a committee substitute, Ms. Travis. Thank you, too. Now we're going to move on to Senate Bill 573, which, Mr. Crawford, I think you've been asked to present that to the committee.
I have, Mr. Chairman, and if it's all right with you, I'm going to ask Bruce Bowers if he doesn't mind coming to the table.
I'd be glad to have Mr. Bowers. Thank you, gentlemen, for coming and being with us today. Appreciate your time, Ms. Ritchie.
I realize that you have some proposed.
Yeah, no. Appropriate time, I'm going to talk about a little history here so we get that cleared up.
Yes, sir. Thank you.
If you don't mind, Mr. Chairman, I'll let him actually present.
Sure.
You can take that now.
Yes, sir. Please,
Mr. Chairman,
Mr. Bowers.
Members of the committee, my
Verify
name is Bruce Bowers, and along with my colleagues in the back of the room, I represent a group of condominium developers, all here in Georgia. Novair Corporation, Post Properties, the Lane Company, and another one who I will remember before I leave here.
All right.
But Cousins, thank you, sir. Thank you, Lewis. Cousins Properties, I'm sure you've heard of this one also. And these developers all are in the condominium industry throughout the state. And they currently are subject to the Georgia Condominium Act, one of the provisions of which prohibits condominium developers and buyers from contracting to allow funds that are held in escrow from being used in the development of the condominium project. This puts condominium developers at a competitive disadvantage with developers of single-family detached housing, where such a term in a contract is permissible under Georgia law. In other words, if you're going to buy a single-family home from a developer, that developer can request in the contract, and you can choose to accept or not accept, that a portion of your escrow funds could be used for the construction of the project itself. Condominium developers would like to have the same right under Georgia law, that is to provide by contract that those funds be used, and currently the law doesn't allow that. There are several protections in the statute as proposed, or in the bill as proposed, that would be for the purchasers of these units. The first protection is obviously that they don't have to agree to the term of the contract anyway. They can either choose to strike it and see if they can reach an agreement with the developer or not. They can choose to purchase another unit if they want, or if they choose to accept the terms of the contract, the statute would require that at least 1% of the funds still remain in escrow. That's a first point. Second point, the statute would require that all of the money that is used for the project be used for construction of the project itself. They could not be used for advertising. They could not be used for marketing expenses. They couldn't be used for salary. The point of them being the funds being used for construction is that is collateral that is established for them. The lenders who are lending against the collateral then would have a reduction in their collateral, and it creates a relationship, as not necessarily a contractual relationship, but a relationship between the buyer and the lender, such that if the project does go south, they have the opportunity to get their unit completed. The other provision of the bill also is that an investor in real estate who purchases more than one unit is not subject to this term anyway. We have met and dealt with the real estate investors groups, with the realtors, with the Bankers Association, a number of other different groups, and have had no opposition expressed by any of these groups in the amendments that are being proposed here.
Mr. Chairman, one other thing too. In that contract, the provision
yes.
page 2,
Yes.
lines 5 through 8 must be as such in the contract,
Yes, sir.
and it is required to be in bold print in the contract. So it's a special disclosure, right?
Correct. Discussion among the committee members. Mr. Brooks. Yes, sir.
If it's in escrow, and we take it out and we use it for construction,
Yes, sir.
and it's no longer in escrow, it's now a loan. Is that correct?
It is not. It would not be. You're saying it would be. Your question is it a loan then to the developer from the?
Because the money is when it's in escrow is there for a different purpose. You take it out. I'm just asking the question. You take it out, then it's no longer an escrow. It's now a loan to the developer to finish his project.
Well,
is that correct?
No, sir. It would not be a loan for the developer to finish the project. It would be an application of the escrow money towards improvements in the development itself. The application. It'd probably be helpful to explain how this often comes up. What happens is in the condo market, when folks want add-ons to their condos, or when they're trying to have marble countertops put in their condos or something like that, a developer often has to come out of pocket for those without any certainty other than the escrow itself that they'll be able to recover the cost of those if the contract isn't honored or anything like that. So what happens is in the market, a lot of times the escrow funds are used to deal with the add-ons and those kind of things in the development of the project itself.
Okay,
Mr. Crawford.
Can I follow up on that to answer your question?
Okay, go ahead.
Actually, you're taking money from escrow and attaching it, which is in escrow after the construction loan is made. It's attaching to the real property. You're just converting dollars into improvements on the real property. So the secured lender would have, if they approve the secured lender when they make the loan, it's got a copy of the contract that is between the two parties that includes this language, so it's not like your lender is at risk because it's being converted to...
Actually, the lender is better off because they then have a reduction of their overall collateral. There's one other point also that I apologize I left out, but by the terms of the bill also, this would only be applicable to condos that have a value of over $150,000. Any condo with a purchase price less than that, the amendment would not even allow the contract to contain the term that we've talked about here.
Any further discussion?
Did that answer your question?
Yes, ma'am.
You're converting it to real estate.
If the person in the country decides, not to agree to it, then how will that affect that person for not saying like they can
Let me make certain I understand your question. If the purchaser tells the developer, I'm not willing to sign this contract, it'd be no different than any other term of the contract. The developer would then have the option of, well, we can strike this and proceed and negotiate about other points, Or the developer could say, well, these are just our terms, it's just like our price. If you don't like our price or any of our other terms, you may need to go find another.
It's open market.
It's open market.
If you would look in front of you, I want you to call your attention to proposed amendments to Senate Bill 573. And I had a discussion with Senator Carter, and I think as a, quote, knowledgeable provision that you don't want to have the buyer come back and say, well, I didn't realize that was what I was doing. I suggested to him, like we do in real estate contracts, when you have the arbitration clause, people saying you're signing away some of your rights, that you initial that. And I suggested to Senator Carter, and I want to get your thoughts on it, Mr. Bowers, that we have just a provision that says on page 2, lines 4 to 6, I'll read the sentence: a contract which permits use of the advance payments for these purposes shall be initialed by the parties to the contract, and
Yes,
includes the following caveat. Then we go into the language.
We would have no problem with that whatsoever.
Yeah, I think it's always just good to say that would hopefully remove somebody later say, well, gee, I didn't realize I was signing that. You didn't tell me that or whatever. Well, you initialed it. So you had to be informed what you were doing by the fact that you was called to your attention by your having to initial it. Any thoughts? Ms. Oliver?
I guess I'm really, the thing that's confusing me is the difference between a construction loan and a closing of a contract. You're really not, an escrow in terms of purchasing a real estate is relevant prior to closing. But it's really a construction contract that you have with these people, not a...
Pre-sale contract.
Yes.
Pre-sale contract.
And that's it.
Yeah.
Yes, I understand you. Yes, it is.
And that's why it's relevant where the escrow goes. And in the worst case scenario, and the original policy behind this, I guess, tell me if I'm wrong, the original policy about this is that the consumer put $5,000 in escrow, and if the condominium goes belly up, the buyer gets his $5,000 back.
Mm-hmm.
In this case, if the condo builder goes belly up and they've used some of the escrow for construction, they're not going to get their $5,000 back. That's the gist of it.
And that's where I was trying to go.
That's the gist of it.
I mean, there are 2 points there. To answer your first part of your question, I'm assuming the same things you are about the original policy. It was a consumer protection at a time when, frankly, the condo market was not exactly what it is right now.
Exactly.
I mean, most condos are on a lower end and lower down in the market price and those kind of things. To answer your question about what happens if there is a default on the construction, again, keeping in mind by the builder, the proceeds have now gone to construction of the project, which has lowered the which has increased the collateral that the lender now has. The lender's now in a position where it's
liquid.
got... What's that?
The lender's less liquid. In the worst case scenario.
Less liquid.
Lender.
The builder. The builder's less liquid.
I'm assuming the builder, I mean, your question is default. I'm assuming the builder's is no longer helpful.
Right.
But you have a lender now which has increased value of its collateral, but will only realize the full value of its collateral if a unit is finally closed upon after the sale of a partially completed project. So it's in the lender's best interest at this point to see to it that the project is completed so they realize the full value of their loan, and the purchaser then completes the transaction for the purchase of the condominium so the lender gets paid off.
I'm going to vote for this. I have no problem with it, but now I understand it.
Yeah.
It's dollars enhancing values to real estate.
And the condominium, Mr. Cousins, has 1,000 times $5,000 escrows, so it's a big pool of money for him, and not so much for the consumer. I understand, and I'm going to vote for it.
Mr. Chairman, as a follow-up to that,
Crawford.
if everybody doesn't agree, it's not going to work anyway. So you got your lender who's got a copy of the contract when they make the loan. Both parties have signed off on it, so everybody should be on the same page. And if there's a problem, they've all agreed to it, and they've created the problem among all three of them.
I think that the lender and the builder are of equal parity. I don't think the purchaser is very equal in that relationship, but they can buy it or not buy it. But the bad side of this is the worst case scenario is if the builder goes belly up, the escrow is not going to be there. but the lender is the
But the
protection.
contract's still good.
Yeah.
The contract's still good. And the lender, who is probably going to be taking the place of the builder, is saying, we're going to finish it out, and your contract will still be honored, et cetera.
And a builder which has gone, one other point if I may, a builder which has gone belly up, in these contract
not
situations,
Tom
the escrow account is often held by a builder in their builder's escrow
So,
account.
so he's going to use it away.
And you know,
Right.
realistically, you're
Right.
often faced with that
Yeah.
same issue
It's
either
not
way.
in the
whether-
third party's hands, what you're saying.
Precisely.
At the appropriate time, Mr. Chairman, I'm happy to make a motion.
Okay.
Councilman,
Mr. Bruce.
Is there something in there that makes it real, because I'm looking at it as, I mean, I've closed on houses,
Yes, sir.
and they put piece of paper after paper after paper, they just throw that stuff at you and tell you to sign it. And a lot of people just do that because they want whatever they're buying. And so is there something in there that makes it real clear to the purchaser that you could lose this escrow money if the builder goes belly up? I mean, because a lot of times the person buying that house doesn't have the lawyer in there with them. The lawyer is usually in there representing the builder.
Well, part of what I was doing was that initialing the clause to be sure it's brought to the buyer's attention that provision's in there.
This is not
understand,
closing,
but
this
some-
is sales contract. This is not closing.
But they still, but I was just using the analogy of the closing. The purchaser is still in a situation, usually they don't have a clue half the time what they're signing. But escrow always meant to the average person that this money was being held in the event of some
It's
problem.
good faith deposit, is what we usually
Yeah.
call it.
And
So in terms of escrow, it's really a good faith deposit.
Exactly. But the person in this scenario could actually lose that good faith deposit through no fault of their own if the builder is doing something that causes them to go belly up. So I guess I just want to make sure that the consumer is protected in this thing. And I know you can say, well, they're protected because they read it, but a lot of times they don't understand it. And a lot of times they're not represented by counsel in those transactions. So can we put something in this that makes it real clear that signing this, you could lose the money that you put in escrow? I know lawyers don't like that, to be that explicit.
I suggest we hold that thought, Mr. Bruce, and work on it some if you'd like, with either legislative counsel or yourself, and let's see if it gets a wording. I want to go on some other portions of it. Mr. Crawford. No questions? Okay. The other thing we're looking to do, if you remember through the committee, we had House Bill 1243 come through the House Judiciary, and this was based upon our having the various parties come together. And Ms. Hamilton, I'm going to ask you maybe to come up here and let's talk about this for a minute. You can stay here, be fine, but I was going to ask, be sure that everybody's understanding, even from your side. And I've talked to, again, Senator Carter about this. I've talked to Mr. Massey, Mr. Bowers, who represent the condominium associations. The bill we had, 1243, was to do a correction in the law that we felt was just an onerous standard that no one could actually meet when we dealt with trying to correct development deficiencies, defects.
Yes, sir. Currently, I'm Sue Celestica Hamilton with the CAI, and currently the law says that you have to have 100% of your residents agree to bring suit after you follow the procedure that was put into the law 2 years ago. And this 100% is impossible to reach because oftentimes the developer holds on to units. So we asked that be lowered to 2/3. The rest of the changes were procedural that were agreed upon. And the home builders, the CAI, and the realtors and the contractors all agree on the language that is now in this bill.
And and so we had everybody get in the room, resolve the concerns each group had. And if you look on the copy you have of House Bill 1243, we look on page 8. It doesn't read 100%, but its meaning is 100%. It says the association first obtains a written approval of each unit's owner whose interest in the common elements or limited common element would be subject to the action. Well, first think, well, each one may be 2 or 3. The ownership and the rights to the common areas, of course, applies to everybody who owns a quote unit, whether it be 5 or 50 or 500. So we felt it was just a standard beyond reach when you put it that way. One reason would be a developer, builder may be owning one of the units themselves, so they're not going to vote to sue themselves. Point being, we had the language first modified. If you look on page 9, starting on line 2, the members of the association have voted to approve commencement of an action by 2/3 of the vote cast, comma, by statutory written ballot, as provided in Code Section 14.3.708. The next part, or have approved commencement of an action by the affirmative vote of more than 1/2 of the total membership at the meeting of the members at which a quorum is present. It's that second phrase that caused the problem. Some people say, well, why we have a difference? And I agree, I'm not a problem with that. Let's go to make it all 2/3. So it's 2/3 either way you go. And that way it's not a impossible standard to reach. The rest of it is mostly clarifying language that was in the law that was unclear. We were taking what was a ALEC model provision on this point and adopting it. I don't know if their model provision had that language that we use or not. That was history that I'm not clear on, but our desire is to have continuity about the vote. And if you look on the sheet again, we're talking about adding House Bill 1243 to Senate Bill 573 and amending that language beginning on page 9, lines 2 to 6, as read in the sheet on the folder you have. And I talked to Mr. Bowers, Mr. Massey. We had you talk with your representatives of your association, and as I understand, they say that's all right.
Yes, sir.
Part of it.
Yes, sir.
Let's try to just make good law. That's what we're doing, not trying to hoodwink anybody. And I'll say this, I've talked to Chairman Earhart. He was the one that had, I think, the biggest concern about that part of it, and with that change, he says it's fine. He's okay with it. That's the discussion. Any discussion among the committee members about it? Any question of the presenters?
Oh, I'm sorry, the Community Association Institute. It's the Association of Homeowners Association.
Yeah. You have Mr. Randall Lipschutz here today, who's the attorney that is, I think, head of the director.
I'm just on one of the committees.
On one of the committees, okay.
One of the committees that works with the association.
All right. And I've had deals with Ms. Lipschutz over the years. Do we have a motion as to, first of all, House Senate Bill 573? I get my numbers right.
I move 573 do pass.
We have a motion do pass on Senate Bill 573.
I got a question.
Yes, sir. Question. Open discussion.
I was just talking about what I was talking about.
Yes, sir.
And I'd like to, at the appropriate time, I'm thinking this is it.
Okay, we're going to get there, right.
Okay.
We can hear, we have any amendments to Senate Bill 573?
Yes.
Mr. Bruce.
In the language on page 2, toward the end there, line 6, 7, and 8, somewhere in there, I was trying to work with it to do this
right
quick. To add something that would say, and if the seller defaults, the buyer understands that some or all of the escrow funds could be lost, or something to that effect. I'm seeking help here. I just want to make sure that the consumer knows.
The reason you're going to have a tough time drafting that is, because I've been thinking about it, is that the circumstances, the potential of the circumstances about default is going to be so varied, it's going to be so infinitely varied, that the consumer is likely to recover in most of those situations, if not.
You're right, because your default may be a default under the terms of contract. I think what you talk about is a question of going into bankruptcy where there is no longer available the funds, perhaps. I'm not.
Okay, but the point that I'm making, if the consumer signs this, they understand that they could lose it for whatever the reason is, but they understand. That's all I'm trying to get at, is to make sure that before they enter into this agreement, that they understand that this $5,000, because that could be a lot of money to some people just going into buying this property, and all I'm trying to do is make sure that they understand what they're signing, and for whatever the reason.
Yes, ma'am.
You're trying to put a notice provision, a notice of it, that if someone falls. Now, what are you saying?
Here's an idea. I think, I'm not saying I support this, I'm just helping you with the language here.
Fine.
You could add at the end, on line 8, page 2, after may be used for construction purposes by the seller, you could add, comma, and could adversely affect recovery of the escrow funds.
Said payment could.
And said
Mr.
payment
Bauer,
could,
you want to say something?
Yes,
could
sir.
adversely affect
Yes,
recovery of funds.
Yes, sir. If I may, Mr. Chairman, respectfully, Representative Roof, I will tell you that from the standpoint of the condominium developers, one of the things, if go back to my initial statements here, one of the things that condominium developers are currently dealing with is they are at a competitive advantage to single-family developers who may do exactly what we're discussed here without any form of disclosure whatsoever in bold, without any form of requirement of a 1% holdback, and without any requirement that it be done on only those homes that are greater than $150,000. So as a potential buyer who hasn't decided yet whether to look at a condominium or a single-family home, or to have two contracts in front of them and see some of that language which is being proposed, it is one more thing that puts the condominium developer also at a competitive advantage in that environment, where a single-family developer doesn't have to do any of those things.
I understood what you were saying, and quite frankly, I think the language I'm talking about ought to be in both of those agreements. You know, so that the consumer just needs to know what they're signing off on. I'm not objective to what you have here.
Yes, sir.
I'm just trying to make sure, and I guess I'm just going by my own experience. You know, when you sit there and you watch and throw paper after paper after paper after paper, and most of these folks, that $5,000 may be a chunk of money for them, and they need to know and it's fine if they sign off on it, then fine. But they need to know that you could lose this $5,000 that you put in escrow if this project goes belly up, for whatever reason it goes belly up.
Mr. Crawford.
Mr. Chairman, I thought this is not mandatory. This is permissive in the contract. Because if the contract doesn't provide for this, it doesn't exist anyway. I thought that what was here, and by putting it in bold print, and then with your amendment of everybody having to initial it, I thought that was the notice provision. That is a notice provision.
There's nothing in there that says, as I'm seeing it, there's nothing in here that says I could lose my $5,000 if this thing goes belly up. What this says is that the developer could use the money for building, for construction. It doesn't say that if he goes belly up that I'm going to lose that money.
But it also says, if the contract for the sale of the condominium unit so provides, on line 22 of page 1, so it means that it doesn't even have to be in the contract.
But if it is, it doesn't have to be, but if it is, all I'm saying is I want to make sure the person understands it. I'm not against the use of the money for the purpose that you have here. I just want to make sure that the person knows that this money could be lost.
Mr. Chairman.
That's it.
Yes, sir.
At the proper time, I'd like to make a motion.
All right, hold on. We're dealing with the, first of all, we're dealing with the language here, and I think what we've got in front of us is a desire through Representative Bruce to amend that language, and I don't know if we've got any specific language out before us yet, do we?
Well, Mr. Chairman, I don't think we've, I'm going to ignore this for a second, and I'm gonna
I know, we're back.
suggest to Mr. Bruce that if he wants to add at the end of the language on line 8, page 2, replace the period with or before the period, say comma, and said payment could adversely affect recovery of escrow funds. That's one way that may accomplish what he wants to accomplish.
Okay, to the average Joe Blow, would they understand that versus
Well,
saying?
you can't.
I'm just asking.
I know. I'm saying
versus saying that you could potentially lose this money. It's as simple as that.
I think the language we're talking about in here is there for that very purpose. And now you say it wasn't to you broad enough to encompass the fact lose the money, and then what Ms. Oliver's brought up is trying to say, well, there's something else to be done there that be at the end, and said payment may adversely affect the recovery. Is that what you used? Just read what you had
Yes,
for
sir.
me.
May be used for construction purposes by the seller, comma, and said payment could adversely affect recovery of escrow funds.
Okay.
I'm not making that offer, I'm just suggesting it.
I know. Just write down so
it works.
Comma, and said payment could adversely affect recovery of escrow funds. That's what you're suggesting as a motion. You make it as a motion?
Yes.
All right, we have a motion to amend at the end of line 8 of page 2, making the period a comma and continuing the bold print within said payment could adversely affect recovery of escrow funds, period, at that point. All in favor of the, yes ma'am? No comma? To take out the comma after self. All right, you're correct. No comma. Appropriate punctuation. Do we have a, all right, ready for the vote on the motion? All in favor of the motion, I think we better do a hand raise. All, raise your right hand. All opposed the motion? 3-2. The motion passes as to that language.
I have another amendment, Mr. Chairman.
Yes, ma'am. Second amendment.
I offer the amendments that are set forth in this addendum.
Let's do them separately. Then we have the amendment about the by the parties to the contract.
Yes, sir. I make that motion for page 2, lines 4 to 6.
I think we're really just talking about. Let me suggest something because I just read this. I'm saying I want it really initialed by the buyer to the contract, not the parties. It's a notice I want the buyer to accept and be aware. So I'm going to amend what I'm proposing here and strike be initialed by the parties and make that by the buyer, as we use that term under the contract. In other language.
Yes, sir. With that adjustment, buyer replacing parties, I make the amendment.
All right.
Motion to amend.
Got amendment to the amendment, replacing buyer. Any objection to that amendment? All in favor of the amendment of page 2, lines 4 to 6, as stated on the sheet in your folder, signify by saying aye.
Aye.
Opposed, like sign. And the next one we have is to add House Bill 1243 to Senate Bill 573. We got a motion to amend. All right, that amendment, I'm going to get that next. First I had it. Motion is to add 1243 to 573. Any discussion on the motion? All in favor? I'm trying to think through in this second. I may want to have an amendment to the amendment on that. First we have the amendment. And now I'm going to suggest the amendment to that amendment will be on page 9, lines 2 to 6. We're going to change the where it states more than half and insert the language at least 2/3 of the total membership. We have that as amendment to the amendment. Any discussion on it? All agree with that? And we're back to the original amendment, which is the amendment of adding House Bill 1243. All in favor of that amendment signify by saying aye.
Aye.
We have all the amendments. Any other amendments to be offered? Mr. Crawford.
Chair, at the proper time, I'd like to make a motion to table this to the next meeting.
All right.
Where we could have, I'm not opposed to what you're trying to do. I'd like to though have it rolled into one. Let
Look at it,
legislative council
prepare it.
and our council prepare what we're going to vote on to make sure we have not messed up both bills. And it's not, I'm not opposed to the notice, I'm not opposed to anything.
I understand. A motion to table has priority. If you're making that motion this time, we have a motion.
I'd just like to be able to see it.
We have a motion to table. All in favor? Any discussion on the motion? All in favor of the motion to table signify by saying aye.
Aye.
Opposed? I think we need some show of hands. All in favor of the motion signify by raising your right hand. We have 2. All opposed, like sign. We have 3. Motion fails for lack of, well, it doesn't fail, excuse me. Now we're back to the original motion, which is a motion do pass as amended. Any other amendments?
Go back through it, let's make sure we got them right.
All right.
Mr. Chairman,
Yes, sir.
did the
Yeah.
chair choose not to vote on that motion?
If I voted, there would not have been I did not need to vote, put that way, because we had a 3-2.
Okay.
We've got a quorum present. So the chair would only vote if there's a tie.
Or to make a tie, but I understand, I'm sorry.
I don't think I vote to make a tie. I think I vote to undo a tie.
I think you can vote to make a tie. But I don't.
What's the rules? Where's the rules? Stop for a
I
second.
really don't know.
I know we got rules,
caused
so
a
let's check it.
problem.
Yes, you did. I want Robert's, I guess it would be Robert's Rules of Order in this case. I'm going to suggest the chair
Yeah, that's.
doesn't pass if there is a, yeah, that's all right. No, let's keep going.
Mr. Chairman, I got a substitute motion.
Hold on just a minute. Yeah. You're right. Okay, we're going to be back on the we had the motion before us at the moment is the motion to accept the bill as amended. Motion to pass as amended. You said you had a motion.
Mr. Chairman, I'd make a motion to print where we can make sure that we've got. My question to you, Mr. Chairman, along that line is, where are you inserting the entire
Yes, sir.
1243
Correct.
onto 573?
Correct.
Where? That's my question.
Yeah, it would come in by draft, and we don't have a draft course in place. Would it be before or after the 543? Ms. Travis?
It would be the beginning of the.
573.
1243 would be the lead into the bill. And I would suggest that, with your permission, I would need to try and carve language so that it would make each subject matter.
It's probably a good point to have this printed before we get to the final review of it. I'm understanding. I understand, Mr. Crawford. I understand. I would urge the committee let it be printed before we can review it, and then we can from there have a better total picture of what we're passing on without, because we do have some declaratory language in the beginning describing the act.
Mr. Chairman, my concern, again, I'm in favor of what Representative Bruce, I voted against it. I have no problem with what Representative Bruce wants to do. My concern is, and you know as well as for all of us have been here long enough to know,
okay,
we get in haste, we may make problems with both of these bills.
The chair would entertain a motion at this point to table consideration of the bill for the purpose of allowing legislative council to do the combinations of what we've talked about as far as the amendments and have it brought back up next Tuesday as first piece of business.
I would so move, Mr. Chairman.
Any discussion on the motion? All in favor of the motion, raise your right hand. All opposed? Okay, we're back to the original question.
Which one is the lead bill? Which one's the lead dog and which one's following?
573
Is the number.
is the lead bill.
But which one is the lead bill?
The lead bill is 573. That was a bill that we were taking with the amendments that we're bringing in for 1243 to be a amendment to it. I'm gonna move to take a recess for 10 minutes. Allow the thing to be looked at. Chair recesses.
We should get it.
Move the door. Right there.
I moved out of that, and they seem to prevail. That'd be a good platform.
Okay.
Mr. Chairman, I'd like to make a
We're
motion.
back from, first of all, we're back from recess. We have under consideration Senate Bill 573 as amended.
Mr. Chairman.
Does anybody need to have the amendment stated to them as where we are? Let me get my sheet back up here.
I think the last motion was a motion to print.
That was, and that was a vote of 3-2 not to print, or let's say not, the motion didn't pass. Excuse me. I want to just get where we got.
Mr. Chairman, I'd like to make a motion to reconsider this bill and the amendments, and let's start over and let's make sure we get this thing right.
All right. I'm just go back over where we are as far as the amendments have been added at this point in time. Okay, then we'll talk about where we proceed this next step. We've had the Senate Bill 573 with the language added as you have published in your folder regarding the initialing of the contract by the buyer. That was the first proposed amendment, which approved. Second proposed amendment was to add House Bill 1243. And of that amendment, there was also amendment to the amendment, which was to change on page 9 at lines 2 and 6 to change from more than 1/2 to at least 2/3. That was changed. Then we've had further amendment. A further amendment was added on Senate Bill 573 on page 2 at line 8 at the end, after seller, continue the sentence to say, could adversely affect recovery of escrow of funds. Said payment could adversely affect recovery of escrow funds. Is that correct? Line 8, yes, sir. On line 8. I want all the members to be aware of what the amendments are. I'll entertain your motion now.
Mr. Chairman, I would like to ask you for consideration first before I make a motion.
All right, sir.
Mr. Chairman, I could make one of two motions. We have a motion to print on the table. I think out of fairness to everyone concerned, I think that is the proper motion, is a motion to print and to bring it back
We've had
first thing Tuesday.
I agree. We've had a motion on that point. What you want is a motion of reconsideration of the motion to print.
Well, no, sir. That's what I'm asking you. Do we need to do that?
If what you talk about, you want to do then a motion of reconsideration of the previous motion to print.
Or
just that motion.
Okay. I'll make that motion if that's what you want, Mr.
We've got a motion for reconsideration of the previous motion to print, and that previously fell by a vote of 3-2. We have a motion for reconsideration. Any discussion on the motion? All in favor of the motion for reconsideration signify by saying aye. Aye. Opposed, like sign. The motion passes. Do we next have a motion? We've got a reconsideration on the motion to print. We're going to consider that at this time. The motion is back before us as a motion to print.
Mr. Chairman, I would move that we leave the motion to print and to take a vote on the motion to print at this point, and for it to also, in that motion to print, for you to consider bringing it back in the next meeting.
So what we're going to do, we're going to have a motion to print, then we'll have second a motion to table.
Okay.
Until the documents before us revised.
That's fine.
All right. Motion would be to print. Any discussion on the motion? All in favor of the motion to print signify by saying aye.
Aye.
Opposed, like sign. And next we'll have is a motion to table.
Table to the next meeting, Mr. Chairman.
Time certain will be the next meeting. This will be the first item of business to be considered on the Tuesday meeting, next Tuesday's meeting. All in favor of the motion to table signify by saying aye. Aye. And that leaves it for time to be printed and to back to the committee with the suggested amendments that we have to it.
Thank you.
Ms. Travis.
I have a question. This is just the phrase that you want
Yes, we did.
And the buyer is used elsewhere in that code section. But is it right to say the initial by the buyer to the contract? I just don't know if that phrase, if that's the right way to say it. I mean, when it used to be the initial by the parties to the contract,
Right.
it made sense.
So in this case, you'll say to be initialed by the buyer, comma, and includes, so strike out to the contract.
That was my question.
That would make better sense. Why don't you do it that way, and we'll consider it as a part of the bill when we bring it back before the committee. Yes, ma'am. Any further business come before the committee at this time? And we'll stand adjourned. Thank you.